Petitions distinguished
Yes.
one
Well, I received.
point 1, 2 and earlier notes on argument are stated.
But I have read. I have thoroughly read all the notes of the state.
Chalan ki gorom hocche. Mr. Dotto,
Yes, sir.
you have already submitted 3. So I think the first one is very short synopsis. The second one covering the first and third one, point number 1 and 2 on merit. On this pair, almost repetition, but some
Yes, yes.
new points have been.
Yes.
It has been put in a nice language, and all the judgments have been distinguished. So that's all. CAV. Written notes on argument filed on behalf of the parties be kept with the record. CAV. So far, the other matters are concerned who are appearing for the petitioners in 2 and 3. These are some related, but they have joined in the post.
Yes.
So not this week for the time being. Let us understand on.
So CEB only in respect
Only in respect of one.
Well,
Deeply obliged.
I'm grateful.
We had a wonderful journey, and we could feel the
Oh.
lawyers. Every time I read the note, I loved it because now it is our.
I
job.
have developed something more on theory of chaos that I will share. I don't know whether he will be interested or not. The theory of chaos.
We'll make Advocate General to be interested.
No, he will not be. I think that possibly he cannot afford to be, possibly, because his
But it
occupation
is
is too much.
humanly not possible. I think thousands of opinions are sought. My little experience with.
Yes, yes, he has experience in that room
Yes,
much before I
yes,
entered that
exactly.
room.
Well, for small things and opinions come to learned Advocate General. State has a huge machinery. It's a very.
In fact, when I entered that office, I found 1 or 2 files which went in that office when Mr. Ray was in that office.
I know.
Had not
Well-
answered.
Eh?
Still pending on this.
No, I had answered. Right or wrong, I believe in the disposing of the opinion files.
This is the other side. This is not the doing only the matters, but always this is something. Now, Dakota, what about the time, Mr. Bhattacharya? Is a very urgent matter, item number 4. Let me take for this. Petitioner is not here.
Yeah.
Please.
My lord, in item number 4, my lord, I'm for the petitioner, my lord. I'm praying for a short pass.
Passover not possible. The part matter will go on. Yes, Mr. Bhattacharya, please start.
This matter, my lord.
Sharid, first up.
ফার্স্ট হাফ না গেলেও তুই ঘন্টাখানেক বাদে কাউকে পাঠিয়ে কারণ এরপর তো ওরাও বলবে
But Mr. Dog requesting to conclude it before Puja vacation.
Yes, yes. But may not be today, my lord. Because I have got a matter fixed at 11:30, which is likely
No,
to
it will continue for some time.
But tomorrow I am available.
And there are other, but according to my notion, right of hearing of the AG is first. Though you have allowed Mr. Sengupta to argue first, but I'll be requesting you to address first accordingly.
কিভাবে
But may not be today. Tomorrow, my lord, I'll definitely.
Very well.
And my lord, so far that item number 4, my lord, may it be taken up on Thursday or Friday, my lord.
দেখো দেখো
I don't know, because of the urgency, it was pressed hard that it should be here. Let us see, it will remain in its position. What will happen tomorrow or day after tomorrow? Now,
But I'm here till 11:30.
তুই ঘুরে আসতে পারিস এরকম তো কিছু হবে না আমি শেষ হওয়ার আগে তো জুনিয়র রেখে দেবো
no. By this time, you can dispose of some of your pending
হ্যাঁ
files.
ইম্পর্টেন্ট ম্যাটার্স
Pending files in your chamber. Including, I'll be requesting you to pursue that bill for the private institutions.
But I have that in my mind.
Oh, sorry, give it. খুলে দিন না ফাইলটা, ফাইল থেকে বার করছেন কেন? তাহলে জন্য
সুমিতা তো সুমিতা থাক না তো কে জুনিয়র
সুবিধা আমার থেকে ব্যস্ত
দিচ্ছে দেখেছো তুই আমার কাছে লাশ হয়ে গেলি
But I will be putting some questions on theory of chaos to you on a occasion.
Question is to create or remove.
No, no, not that. Theory
question
of
to
chaos,
question.
theory of chaos, is a very good. He was a physics background, I suppose. Mr. Bhattacharya has the physics
My
background.
junior has a physics background,
So,
and you know me.
before you start, আচ্ছা আমাকে ইয়ে দাও তো ডিভিশন বেঞ্চের জাজমেন্টটা দাও।
বসো বসো
এটা কিন্তু করে দেবেন।
তুই ওদিকে গেছো কেন ওদিকে যাও কনফিউশন হয়ে যাবে নন্দিনী মিত্রকে দেখলাম না কোথায় দিকটায় গেছে তুই বসে এখানে ওকে আমার ইনস্ট্রাকশন দিতে হবে ডাকাতি হচ্ছে
On 16 December 2016, the notification regarding that first state level selection test for recruitment of assistant teacher 2016 in physical education and work education was notified. Now, we all know that this 26,000 set aside division bench, all these things. This was Group C, Group D, 9, 10, 11, 12. If you kindly, Mr. Dasgupta, please show him page 81 of the division bench judgment.
yes
What I am getting from here, Group C, Group D, was the selection was in terms of of 2009,
no
right?
Group C, Group D, 2000.
yes that was 2009
2009,
9 10 11 12 16
2006.
no
2006.
it's a printing mistake
Oh, it should be 2016,
16
right? And this is also 2016.
yes
Mr. Dasgupta, have you supplied these two rules to me?
yes that's a part of the petition
My lord, also
This is also part of the.
soft copy. No, no.
Huh.
No, no, 19.
no 9 10
My lord, the rules for 9, 10, 11, 12, Group C, Group D have supplied hard copies as well as soft copies. my lord.
এই গ্রুপ সি গ্রুপ ডি এটা বার করুন, এই দুটো আমার দরকার।
আমাকে দাও তবে
Mr. Bhattacharya, why I am looking for this? Because on the analysis of these rules, the division bench affirmed by the Honorable Supreme Court that there was infraction of rules in conducting the selection process apart from other allegations.
parameteria
Parameteria. So the way you are interpreting now the 2016 rule, please take me to that portions where I'll be getting some kind of
I just
similar, not now, according to your time, whatever way you have prepared yourself.
follow
So I need to compare it. If these areas have already been dealt with by the division bench affirmed by the Supreme, my task will be rather a little bit easier.
no I will ultimately take your lordship to that
Very well, very well.
now that before
Very well.
taking your lordship to that I want to also demonstrate the entire issue about the creation of post
Very well, I understand, but I was wondering to that.
yes
Now, please take this notification of 16 December 2016.
yes that is yes
Let me read it for you. As per instruction, reference number such and such dated 20th September 2016. This is the notification whereby the rules called West Bengal School Service Commission selection for appointment to the post of teachers for upper primary level of schools rules 2016 was framed. This is that rule. Now, what is this notification is saying? As per instruction wide reference number, this is the 2016 rule of the government of the Department of School Education, Government of West Bengal, that is West Bengal School Service Commission. Selection for appointment to the post of teacher upper primary to rules 2016. The West Bengal School Service Commission has been designated to conduct state level selection test for recruitment of assistant teachers in physical education, work education in recognized non-government aided sponsored school in West Bengal. Very important, against the vacancies
Yes.
available under the 2016 rules.
Well, that was I was harping that 2016 rule itself delineates the methodology of finding out the vacancies.
So, can I take it that notification date is 16 December 2016 when the employment notification was issued? Then it was made clear to everyone that vacancies will be
Determined as per
against the vacancies available under the 2016,
Right, so,
meaning thereby as per rule 8,
right, so, right, so,
right?
right, so. There's no doubt in it, and no can question it. Now, I was just trying to demonstrate because the affidavit in the state affidavit they have taken this plea that we have administrative power. Therefore, I have taken ownership of the constitution and the administrative power to what extent state can do it and whether they can do it in violation of rules. To that extent, I am not trying to develop it. Now, the last day, I was placing this judgment 2010, volume 6, Supreme Court cases, page 777. This specifically relates to the recruitment.
2010 volume 6 777 কালকে লাস্ট যখন শেষ করার সময়
And my lord would be pleased to find the honorable judges, while deciding this matter, in fact had the privilege to consider all the judgments delivered by Supreme Court so far. But it's very rare question that they have considered almost 25 judgments
By the division bench or the Supreme Court?
by the Supreme Court. I am now citing 2010 6 Supreme Court cases.
দাঁড়াও, এক মিনিট। এটা রাখো। The other thing I'm making it clear, and I have already made it clear, that in view of the fact that the Sweatley State candidate since has already been recommended for appointment, that issue I'm dealing with now,
Yes, lots of
without detaining the other
my
issues.
lord has made it very categorically clear that my lord is considering Lord the
Challenge to
creation
the-
of supernumerary posts and other things.
and maintainability to that.
And not beyond my lord the main challenge to the
Main
entire
challenge,
panel. I'm not.
Very well. Yes, now today, খাতা কোথায় আমার?
2010 volume 6. Because otherwise, my lord, the ratio.
Yes, will be difficult to understand.
Paragraph 2. The facts and circumstances giving rise to the present appeal are that in order to fill up 15 posts of junior clerks in the district Sonepur, applications were invited by an advertisement dated so and so. The advertisement made it clear the number of vacancies could be increased The respondents applied in pursuance of the said advertisement along with a large number of persons, and written examination was held in accordance with the recruitment rules. Before the selection process could complete, the number of vacancies were increased from 15 to 33, and as per requirement of the 85 rules, a merit list of 66 candidates was published. The appointments were made on the said posts. Identical feature. The respondents whose names appeared in the merit list and could not be offered appointment, being much below in the merit list, filed applications before the tribunal praying for a direction that the state to offer them appointments. The tribunal, vide its judgment and order dated so and so, came to the conclusion that appointments were to be offered to all the candidates if the entire select list stood exhausted. Therefore, the tribunal directed to offer appointment. We have same plan, we are agitating, we are waitlisting, therefore we have to give appointment. Then what I am skipping over without the respective arguments. Then kindly come to me Lord, paragraph 9.
No, here the little distinction what I am
They
getting.
were in the merit list. Here. In our case, they were in the waiting list.
And the vacancies were increased from 15. Vacancies were
Vacancies
increased.
were increased before the selection we could make. That's the interesting part. Now kindly come to 9, paragraph 9. If the aforesaid relevant rules are read together, the cumulative effect therefore comes to that after determining the number of vacancies, taking into consideration the expected vacancies, the same shall stand notified to the local employment exchange and advertise the same through other means. Here, Miller Milad was putting me the question at the beginning that the vacancies were identified, thereafter the notification was published. Same thing. The select list after holding the test as required under the 85 rules shall be prepared and published, which shall contain the names of candidates, double the number of vacancies to advertise and determine. Here, Milord, 1.14. There was double. Rule 14 merely enables the state government to relax the eligibility conditions by recording reasons in respect of any class or categories of persons in public interest. Rule 14 empowered that. Here, there is no such empowerment rules. Now, it's important. It is a settled legal proposition, paragraph 11, that vacancies cannot be filled up over and above the number of vacancies advertised. Kindly highlight this. As the recruitment of the candidates in excess of the notified vacancies is a denial and deprivation of the constitutional right under Article 14, read with Article 16(1) of the Constitution, of those persons who acquired eligibility for the post in question in accordance with the statutory rules subsequent to the date of notification of vacancies. Filling up the vacancy, the question of locus, your lordship probably is being always. Now, this is a clear answer. Even the persons, my lord, who were waiting might have been qualified, their rights are affected. Therefore, they have also locus. Filling up the vacancies over the notified vacancies is neither permissible nor desirable for the reason that it amounts to, quote, improper exercise of power, and only in a rare and exceptional circumstances and in emergent situation, such a rule can be deviated, and such a deviation is permissible only after adopting policy decision based on some rationale. Otherwise, the exercise would be arbitrary.
Here the policy decision taken.
Again, read it. I'll let you complete. Filling up the vacancies over the notified vacancies, neither permissible nor desirable, for the reason that it amounts to improper exercise of power, and only in a rare and exceptional circumstances and in emergent situation, such a rule can be deviated, and such a deviation is permissible only after adopting policy decision based on some rationale. Otherwise, the exercise would be arbitrary. Then, filling up of vacancies over the notified vacancies amounts to filling up of future vacancies and thus not permissible in law. This is the declaration of law. That the portion which I was reading is a quotation of some documents. And there the court says, filling up of vacancies over the notified vacancies amounts to filling up of future vacancies and thus not permissible in law. The Supreme Court judgments referred to. Then paragraph 12. In state of Punjab versus Raghuveer Chand Sharma, this court examined the case where only one post was advertised and the candidate whose name appeared at serial number 1 in the select list joined the post, but subsequently resigned. The court rejected the contention that the post can be filled up by offering appointment to the next candidate in the select list, observing as under, quoting from SCC that page, with the appointment of the first candidate for the only post in respect of which the consideration came to be made and select panel prepared, the panel ceased to exist and has outlived its utility, and at any rate, no one else in the panel can legitimately contend that he should have been offered appointment either in the vacancy arising on account of the subsequent resignation of the person appointed from the panel or any other vacancies arising subsequently. But here the vacancies did not arise, was created subsequently.
Panel ceased to exist.
Yes. Therefore, the judgment on the issue is absolutely watertight. Then paragraph 14.
Just a minute.
Yes.
Notification and filing. পুরোই ফেলে না। Yes.
Paragraph 13. In Mukul Saika, the state of Assam, this court dealt with a similar issue and held that, within quotation from that judgment, if the requisition and advertisement was only for 27 posts, state cannot appoint more than the number of posts advertised. The select lists got exhausted when all the 27 posts were filled. Thereafter, the candidates below the 27 appointed candidates have no right to claim appointment to any vacancy in regard to which the selection was not held. There is no selection, nothing. I create post, give you offer. I don't want to tell you the background history. Because I am a court of law, constitutional court of law, I just will not give you the constitutional facts. The currency of select list had expired as soon as the number of posts advertised were filled up. Therefore, appointments beyond the number of posts advertised would amount to filling up future vacancies. And the said course is impermissible in law. A person whose name appears in the select list does not acquire any indefeasible right of appointment. Empanelment at the best is a condition of eligibility for the purpose of appointment and by itself does not amount to selection or create a vested right to be appointed. Lord, the whole claim of the so-called wait-listed candidate is that we have a right to be appointed. And since posts were created for us, therefore, court is not supposed to interfere. That's the Millard's argument. The vacancies have to be filled up as per the statutory rules and in conformity with the constitutional mandate. Then, my lord, paragraph 15, a constitution bench, what will be surprised to find when the short judgment, the Honorable Supreme Court had considered almost 25 judgments on the whole issue. And then says, a constitution bench of this court in Sankarshan Das of the Union of India held that appearance of the name of a candidate in the select list does not give him a right of appointment. Mere inclusion of the candidate's name in the select list does not confer any right to be selected, even if some of the vacancies remain unfilled. But where the vacancies remain unfilled, there also Supreme Court says you cannot do this. And here you create vacancy. Well, I am confining again, Lord, to the constitutional legal authority of the state to create vacancies to accommodate a particular group. Mere inclusion in the candidate's name in the select list does not confer the right to be selected, even if some of the vacancies remain unfilled. But this is more important. The candidates concerned cannot claim that he has been given a hostile discrimination. Reference of various judgments given. Then paragraph 16 is the verdict. A select list cannot be treated as a reservoir for the purpose of
This has
appointment.
been quoted, I suppose, in the judgment of the division bench.
No, all these I had cited.
Is a perennial source of reservoir, perennial reservoir.
A select list cannot be treated as a reservoir for the purpose of appointments. That vacancy can be filled up taking the names from the list as and when it is so required. It is a settled legal proposition that no relief can be granted to the candidate if he approaches the court after the expiry of the select list. If the selection process is over, select list has expired, and the appointments had been made, no relief can be granted. But he had admittedly selection was over,
Panel expired.
panel expired. 2 years thereafter, Willard, the cabinet thought that we shall 3 years after create posts. Why? Purpose is very clear: to quell the administration. Demonstration. And those assurances were given again. My Lord will excuse me if I take a little digression, before an election. Then next paragraph. Well, I read it better. The instant case is required to be examined in view of the aforesaid settled legal proposition. The 1985 rules provide for determining, which my lord was asking, determining the number of vacancies and holding competitive examination ordinarily once in a year. The select list prepared so also is valid for 1 year. In the instant case, 15 vacancies were advertised with a clear stipulation. The number of vacancies may increase. The authorities had taken a decision to fill up 33 vacancies. Thus, a select list of 66 persons was prepared. It is also evident from the record that some more appointments had been made over and above the 33 determined vacancies. Thus, once the selection process in respect of number of vacancies so determined came to an end, it is no more open to offer appointment to persons from the unexhausted list. Then it's important. It is the exclusive prerogative of the employer. Here below, the appellant was the state. Not us, where state is not defending. Where the state went up challenging the direction of the tribunal, how could you direct appointment? Therefore, the Supreme Court says, it is the exclusive prerogative of the employer, that is state administration, to initiate the selection process for filling up vacancies occurred during a particular year. There may be vacancies available, but for financial constraints, state may not be in a position to initiate a selection process for making appointments. Bona fide decision taken by the appointing authority to leave certain vacancies unfilled, even after preparing the select list, cannot be assailed. The courts and tribunals have no competence to issue direction to the state to initiate selection process to fill up the vacancies. A candidate only has a right to be considered for appointment when the vacancies are advertised, selection process commences, if he possesses the requisite eligibility. Now, pausing here for a moment, kindly go through the cabinet decision. State will not burden itself with extra financial liability, creating this post. Finance department says 748 crores, if I am not wrong about the exact number. The Supreme Court says the state can withhold, considering its financial situation, not even fill up the declared vacancies. Here, state may not creates vacancies, and yes, I just give a lordship with the financial burden, which ultimately comes to on our shoulder also. Sum of rupees 262 crores, 40 lakhs, 62,320 for other related issues.
This is per year,
A part of the cabinet decision.
per year expenses.
Yes, yes. This is only for recruitment. Then it has a cascading effect till he retires. Then the paragraph 19 and then a close like this. As the appointments had been made as per the select list prepared in 1995 and the selection process came to an end, there was no occasion for the tribunal to entertain the application in 97, 8, 98, 99 for the simple reason that once the number of vacancies determined are filled, the selection process came to an end. No further appointment could be made from the 1995 panel. And they are saying that my clients are, they said, unqualified. No, unqualified. Unsuccessful, sorry. Unsuccessful to that panel, which has come to an end. You are also not successful in that panel, you are in the waiting list. Therefore, with the conclusion of the filling of vacancies, everything goes now the clean slate. That's the law laid down by the Supreme Court.
Please read down 2-3 lines more.
Once again, I read. As the appointments had been made, as per the select list prepared in 1995, and selection process came to an end, there was no occasion for the tribunal to entertain the applications in 97, 98, and 99 for the simple reason that once the number of vacancies determined are filled, the selection process came to an end. No further appointment could be made from the 1995 panel. The purpose of making the list of double of the vacancies determined is to offer the appointment to the persons for the waiting list in case the persons who are offered appointment do not join, but it does not give any vested right in favor of the candidates whose names appear therein. Paragraph 19, Milord, is conclusive that there is no waiting list, you have no right. That is, again, the court says you have to keep in mind statutory rules and the constitutional provision, which has been, Milord, I try to, Milord, always harp on this. Milord, therefore, this is the judgment which, Milord, in fact, on the issue, pat on the issue where, Milord, the creation of supernumerary post becomes absolutely redundant, illegal, and unconstitutional.
Rational decision on the basis of evidence.
তারপর এটা বার করে 2011, 2001, but I am not really piling up with on the same point. It's not necessary. But another important judgment, my lord, is 2022 volume 7 Supreme Court cases, where, my lord, the defense was sought to be taken as a one-time measure. The Supreme Court said nothing doing. দাঁড়াও বলছি 2022 7 SCC 482 inherent power. Mhm. Now, my lord, kindly come to paragraph 4, facts of that case. Here also the state of Odisha was the appellant. The facts giving rise to the present appeals are as under. All the applicants joined the said ME school as Hindi teacher in or around 88-89. The applicant Sulekh Chandra Pradhan in the lead case before the tribunal Bhubaneswar bench was appointed on 1988 and joined as Hindi teacher in nursing in so. On 12th of May 1992, the government of Odisha Education Department issued a resolution thereby taking over all ME schools situated in the state of Odisha with effect from 1st April 1991. Though the government took over the teachers, including non-teaching staff of the ME school as government servants, Hindi teachers were not taken over as government servants, and therefore the service of the applicants were automatically terminated. This is the background. Then kindly come to my lord, paragraph 13. Ignoring the letter communication dated so-and-so, the respective district inspector of schools issued appointment order in favor of the applicant. Noticing this, the Directorate of Elementary Education Odisha addressed a communication to the district inspector of schools informing that all appointments made by them should be kept in abeyance. It appears that on the basis of the said communication, the services of the applicants Hindi teachers were discontinued with effect from 4th November 96. On 5th September 98, the government of Odisha addressed a communication to the director stating therein that the government has withdrawn its GO number such and such. It is the contention of the state government that the joint secretary to the government of Odisha addressed a communication to the director stating therein that the government had decided to adjust the services, underline these facts for consideration, to adjust the services of 137 Hindi teachers in ME schools against the vacant post. With another communication, the office of the director informed the district inspector of schools that a committee constituted and headed by them should scrutinize the original papers of Hindi teachers, and acquaintance roll of the incumbent should be verified with reference to the cash book of the school from the date of their joining before the adjustment of such teachers in pursuance to the aforesaid communication. It appears that certain teachers approached the tribunal and skipping over, then 16. In the inquiry, it was found that the letter dated 7 July 2009 of the government of Odisha addressed to the director to adjust 137 Hindi teachers, like I make a lateral reference, in place adjust, if you read absorb, then you can have some connection with this cabinet memo. As assistant teachers against vacant posts was issued by suppressing its earlier letter, whereby the letter dated so-and-so to adjust the teachers have withdrawn. The government of Odisha, therefore, with a communication directed the director to remove 137 teachers who were illegally adjusted by the district inspector school. Accordingly, services of the applicant teachers came to be terminated with effect from 15th of March 24. Now that the respective arguments are made, then kindly come to Lord, paragraph 32. And before that, the rules are discussed. Procedure of selection of candidates, everything is discussed. Then court comes to this finding. It could thus be clearly seen that a detailed selection procedure is prescribed for making appointment of vacancies arising in aided educational institution. It could thus be clearly seen that a detailed selection procedure is prescribed for appointment of vacancies arising in the educational institutions. Then must keep over 33, then come 34. It is not in dispute that the appointment for all the applicant respondent teachers have been made directly by the respective management without following the procedure as prescribed under the rules and statute. It is a trite law that the appointments made in contravention of the statutory provisions are void ab initio. Reference in this respect could be made to the judgments. Therefore, this is not merely a pious statement of the court. It is the judicial determination court reiterates. We are unable to accept the contention raised by so-and-so that since the applicant teachers are appointed on posts which were not on granting aid basis, the said rules are not applicable. The said rules would clearly show that they are applicable to aided educational institutions. Undisputedly, the institutions in which the applicants were appointed were recognized as aided ME schools. It is also not in dispute that the appointments so made were subsequent to the schools being recognized as aided school. As such, the contention deserves to be rejected. Now, from this, it is clear that the government from time to time wanted to absorb them. Supreme Court says nothing doing.
In contravention of rules.
Because you are a creature of constitution. And you have empowered to make the rules, you have made the rules. Then how can you violate the rules? This is the basic thing. Now, they wanted to say that it should be a one-time measure. The Supreme Court said nothing. No one-time measure. Now, and one judgment, I would like to cite to show what should be role and duty. 2012 5 SCC.
So then 12 5 SCC 370.
No. নোট করা থাকে তো মুশকিল হচ্ছে। Will kindly come to me, Lord. Paragraph 46. ওরা এইসব করে মানে Paragraph 46, Lord, truth has been the foundation of other judicial systems such as the United States of America, the United Kingdom, and other countries. In Giles versus Maryland, the US Supreme Court ruling on the conduct of prosecution in suppressing evidence favorable to the defendants and use of perjured testimony held that such rules existed for a purpose as necessary component to the search for truth and justice that judges, like prosecutors, must undertake. It is further held that the state's obligation under due process clause is not to convict, but to see that so far as possible, truth emerges. The duty of the judges and the lawyers as well. The obligation to pursue truth has been carried to extremes. Thus, in United States versus Havens, it was held that government may use illegality, obtained evidence to impeach a defendant's fraudulent statements during cross-examination for the purpose of seeking justice, for the purpose of arriving at the truth, which is the fundamental goal of our legal system. Justice Cardozo, in his widely read and appreciated book, The Nature of the Judicial Process, discusses the role of the judges. The relevant part is reproduced as under, quote, "There has been a certain lack of candor in much of the discussion of the themes of judges' humanity, or rather perhaps in the refusal to discuss it as if judges must lose respect and confidence by the reminder that they are subject to human limitations. I do not doubt the grandeur of conception which lifts them into the realm of pure reason, above and beyond the sweep of perturbing and deflecting forces. Nonetheless, if there's anything of reality in my analysis of the judicial process, they do not stand aloof on these chill and distant heights, and we shall not help the cause of truth by acting and speaking as if they do." Now, my lord is really trying to do so repeatedly without asking the questions and pointing out what should be the area of consideration by the court. Court wants to without come to the truth. Now, that another important judgment, of course, this might be said as some sort of benediction. But the Constitutional Court took this into consideration, where the Constitutional Court says the constitutional morality must prevail over the political morality. That is at 2020, Volume 2, SCC.
For a minute.
22 SCC.
Truth or stability?
Huh?
Truth or stability? Truth is preferable
Truth prevails.
because one anticipated argument that they are working for long time. That was the one.
That is the only sheet anchor of argument, sentiment.
So this is Israeli Supreme Court. Truth and stability. Truth is preferable.
Truth is the foundation. Now that this here, my lord, Lordship kindly considers whether the decision is the people who are demonstrating. Therefore, we want to keep them in our bound. Therefore, give them appointment. It's the political morality.
What is your view? Supposing in a situation, something is there, if it is disability is bring on, that there will be chaos in the society or there may be a disturbance in the society. What would be the role of court in that situation?
Court will afford the dignity and principles of constitution.
Of course.
If the constitution,
Whether striking a balance should be explored first or straightway.
Well, the balance would come later. If your lordship finds that it can be balanced within the parameter of the constitution, then you can. Like that one individual, Shuma, she was found to be suffering for cancer, a deadly disease. The court exercised its power, not asking to give appointment, directing the executive to consider. And executive had considered this is permissible, exception, one or two cases. And that's why when this matter is asked before the Supreme Court said nothing big. Because the Constitution is the parent law. these institutions are all creature of constitution. Like, now the Supreme Court has also said that we do not accept the colonial court's interpretation because their interpretation was in the light of that particular political situation. So we have to give interpretation on the basis of our constitution, which speaks of equality, which speaks of personal dignity, respect.
And that is why possibly, subject to what you say, it is easier to follow the old decisions of federal court, privy council in respect of civil matter. But
Yes.
no such
Because
as
civil
such
disputes are personal.
personal, and there is no as such change in this scenario.
No, that is personal. Dispute between the two parties. They will largely, the court wants to see that the society is not really disturbed because of two parties dispute. That is fundamental. But here, Milord, we are here to, Milord, uphold and, Milord, preach the constitutional goal. The constitution, Milord, is outcome of a freedom struggle. If your Lordship must have gone through the, Milord, the history of creation of constitution. This is the direct outcome of the freedom struggle. When the Britishers ultimately found that they cannot continue to rule over the country, they decided to leave. And while they decided to leave, they have done some political heinous crime, dividing the country. But the question remains, how would you rule? Churchill had said, if we leave this country, then they will not be in a position to rule. And they will destroy whatever infrastructures we have developed. That was the challenge to the country. And that's why the Constitution Committee sat and discussed for 3 years. And
Was Dr. Ambedkar was satisfied in all respect?
Dr. Ambedkar was ultimately, this preamble is his own draft, not the entire constitution.
Not the, but he had some reservations in some areas.
No, that he said there are some reservations which we cannot achieve. He said that we are giving the political justice, one man, one vote, one value. But is it really justifiable? He said, he asked him. Because in our country, we find a Dalit, he doesn't have a right to, he came from Dalit family.
Yes.
He was forced to sit in a school separately, having a one water pot hanging.
Yes, he faced all these things.
Yes. Therefore, it is not possible unless you can achieve economic justice. That it was clear.
That's why I'm telling you, this was the overall view. I purchased a book from the footpath at Gwalior. A bookseller was selling 2 letters of him addressed to Gandhi. This was my eye opener. What was
course,
it?
Now, therefore, here, the so-called sentiment doesn't come into play because they were no this waitlisted candidates. They were nowhere. They were brought in to absorb. That I will show what the absorption means. Before that, what I was going to just refer to, this is not for my personal satisfaction,
Yes.
that the constitutional morality must prevail. Now, this was, of course, in the background of the rule of defection. There the court says that what should prevail is not the political morality, but the constitutional morality. Like paragraph 86 onwards, I shall just place 2-3 paragraphs.
Yes, sir.
Paragraph 86. Before we proceed to record our reasons, it is pertinent to reflect upon the statement of object reasons to the Constitution 52nd Amendment Act, which states that the issue of defection has preoccupied the national conscience from the 1960s. The importance of the same stems from the fact that it has the potential to cause extensive damage to the democracy. In this regard, having experienced earlier governments falling due to such practice, the legislature introduced the bill inserting the 10th schedule for so and so. Now, I just skip over, my lord, paragraph 87 and 88. Therefore, it can be clearly concluded that the 10th schedule was brought in to cure the evil of defection, recognize the significant impact it has on health of our democracy. The 91st Constitutional Amendment also strengthens the aforesaid view that a law needed further strengthening in order to curb the evil of defection. The aforesaid amendment introduced so and so. These provisions bar any person who is disqualified under the 10th schedule from being appointed a minister or from holding any remunerative political post for the date of disqualification till the date on which the term of his office so and so. Then, but I am not troubling my lord with the other paragraphs. And here, ultimately, my lord, the questions of constitutional morality comes. If your lordship kindly comes to the concluding part. It's a huge judgment. Hmm? 193, yeah. না তুমি কোনটা বললে একশো নব্বইটা conclusion. Now, in the light of discussions above, paragraph 190. Paragraph 190. The Speaker, while adjudicating a disqualification petition, acts as a quasi-judicial authority, and the validity of the orders thus passed can be questioned before this court under Article 32 of the Constitution. However, ordinarily the party challenging the dismissal is required to first approach the High Court. So and so. The Speaker's scope of inquiry with respect or acceptance of rejection resignation tendered by a member list is limited to examine whether such a resignation was tendered so and so. Once it is demonstrated that a member is willing to resign out of his free will, the Speaker has no option but to accept resignation. It is the constitutionally permissible for the Speaker to take into account any extraneous factors while considering the resignation. The satisfaction of the Speaker is subject to judicial review. The resignation and disqualification, I am not reading that. Therefore, this is more important. Even in Speaker's case, the Supreme Court says that it is the constitutionally impermissible for the Speaker to take into account any other extraneous decisions. Therefore, the constitutional issue is more important. I have started with the power of President is reviewed by Constitutional Court. Here also power of Speakers, the Speaker also doesn't have any authority to do something which is not provided under the Constitution. Now, key. Now I shall take your lordship to what would be the meaning of absorption.
Supplementary. 1991 supplementary to SCC 553. No. এটা না,
একবার চোখ দিন।
এটা constitution one.
Okay.
Yes.
Very pertinent, my lord, the discussions are made in paragraph 145, 146, 148,
Exactly.
150.
I was searching for that exact term. You have the constitutional morality must prevail and
Yes,
cannot
yes.
be replaced by political morality.
Then, my lord, may I have the privilege, my lord, to place these paragraphs where, my lord, these issues are very interestingly discussed.
Been 145, 146.
Now, my lord, kindly, my lord, since it's interesting, I'm also getting interested. The lordship is quite interested. Now, kindly come to, my lord, paragraph 115, the phrase violation of constitutional mandate speaks for itself and it does not need much elaboration. A constitutional mandate can be understood as what is required under or by the constitution. For instance, in Rajaram Pal vs. Lok Sabha, the phrase constitutional mandate is used in this sense, quote, on a plain reading, Article 122(1) prohibits the validity of any proceedings in Parliament from being called in question in a court merely on the ground of irregularity of procedure. In other words, the procedural irregularities cannot be used by the court to undo or vitiate what happens within the four walls of the legislature. But then the procedural irregularity stands in stark contrast to substantive illegality, which cannot be found included in the former. We are the considered view that this specific provision with regard to check on the role of the judicial organ vis-a-vis proceedings in parliament uses language which is neither vague nor ambiguous and therefore must be treated as the constitutional mandate on the subject, rendering unnecessary search for an answer elsewhere or invocation of principles of harmonious construction. Then on the 116, on the point of violation of constitutional mandate, although we are of the opinion that there was an error committed by the speaker in deciding the disqualification petitions, the same does not rise to the level which requires us to quash the disqualification orders in their entirety. The specific error which we have identified relates to the period of disqualification imposed by the speaker in the impugned orders. However, this error is severable and does not go to the root of disqualification and thus does not require us to quash disqualification orders in toto. Our findings on this issue highlighted above are dealt with a separate chapter. Therefore, here, my lord, again, that if ultimately constitutional principles are upheld, whether here and there some errors, the court is not going to interfere. Because ultimately, constitutional mandate was that if someone has defected, he should go. Whether some errors, the order was not passed, not hurt me or not, this is immaterial. Then, Miller, kindly 146. exactly this one Lordship was probably searching for. I was also searching for. The contention of the respondents. Got it? That the political exigencies require such measures to be taken needs to be rejected. The constitutional silences cannot be used to introduce changes of such nature. Here was a glaring. And they specifically say that the decision is taken because people were agitating. Political expediency. And by that political expediency, you want to change the constitutional necessity. Then, Lord, I take your Lordship to the very important two judgments. In the light of, my Lord, the decision of the cabinet, I just read, my Lord, the decision of the cabinet, then place it. The cabinet decision was can leave the text of the cabinet decision. Josh pe diye chota.
Supplementary affidavit to the
বার করে দাও
19 June supplementary.
ক্যাবিনেট দিয়ে যশোর হাতে কাছে থাকা উচিত
Is a part of supplementary affidavit, na?
19 June.
দাও দাও রিড পিটিশনেরটা দাও ওটার সাথেই আছে সেট করা আছে অন্য জায়গায় দেখছো কেন
Yes, it was very interesting decision. My Lord, kindly come to the page 3 of the decision. I am not troubling my Lord with the others.
Page 3.
Eight over the school. Page 3.
No, not page 4. Supplementary affidavit.
I was the page 3 of the cabinet memo. Got it? Yes, my Lord. Will I kindly come at the top, my Lord, Roman 3. Roman, but III.
I.
The school education department also considered the proposal of Commissioner of School Education with regard to the demand of waitlisted candidates of physical award education for appointment in their favor. It is failed to consider their demand favorably to instill confidence in the general public in the matters pertaining to education and involving public employment. Now, let instill confidence in the general public by not following the rules and constitution, but to quell the agitation. Then kindly turn the next page. What is the decision? The Commissioner of School Education at the top, third line. Got it?
Page
The next page.
Supplementary page 6.
page 6 internal page 4
Yes, internal page 4. The Commissioner of School Education, the fourth line from the
yes
Viday's proposal dated 4th May 2022 has proposed to create 1,600 numbers of supernumerary posts to absorb all waitlisted, to absorb. And then again, department's view. creation, and will kindly come to II 1600 supernumerary post for absorbing the waitlisted candidates. But I am noticing in nowadays some of the bureaucrats are a little more intelligent. To save their skin, they use proper words.
They maybe are conscious that under what environment they are working.
That we have said for absorption. And what would the absorption mean? Absorption means that they were already in employment.
In whatever form they are.
Now,
Maybe
What
their
do-
appointment is not regular.
they,
Regularize their appointment
Ah.
like that situation.
therefore, the cabinet decision was to absorb. Creation of post to absorb the persons who are working, but there was no post for them, no sanctioned vacancy. We create vacancy, which is oftenly faced by this court time to time. Now, what would really absorption mean judicially? Kindly, Miller, takes Miller. Kindly, 1991 supplemented to SCC.
1991 supplementary to SCC 553.
553. Paragraph 8. Now coming to the question of seniority, the term absorbed in service jurisprudence with reference to a post in the very nature of things implies that an employee who has not been holding a particular post in his own right by virtue of either recruitment or promotion to that post, but is holding a different post in a different department, is brought to that post either on deputation or by transfer, and is subsequently absorbed in that post, whereafter he becomes a holder of that post in his own right and loses his lien on his parent post. Therefore, someone who is already in employment, but he somehow or other comes to any department or place where there is no post for him, then creating a post to absorb him.
The supernumerary post can be created to absorb.
Absorb. So that when someone whose employment is not thrown out because of departmental latches. There is a preponderance of the probability that it may so happen. Someone was already working, but there was no post for him. He cannot go away. Therefore, create a post which is called supernumerary post so that the other persons who are in the card are not affected. But his personal service is protected. That's why without the Supreme Court very categorically say, I am reading once again. In service jurisprudence, coming to the question of seniority, the term absorbed in service jurisprudence with reference to a post in the very nature of things implies that an employee who has not been holding a particular post in his own right by virtue of either recruitment or promotion to that post, but is holding a different post in a different department, is brought to that post either on deputation or by transfer and is subsequently absorbed in the post, whereafter he becomes a holder on that post in his own right and loses his lien on his parent post. No one asserts that the instant one was a case of the absorbed sales tax inspectors being initially sent on deputation from the post of block level extension officer. Like this was vis-a-vis that particular case, I'm not troubling, my lord.
No, are you suggesting that the cabinet decision may be correct to absorb, but which cannot be applied to this to give appointment to them?
Cabinet decision without would have been appropriate if they found that some people are already working.
No, if we take it that it was intended to absorb some.
Intended to absorb. Absorption means that somebody is in employment.
So applying to it to the give appointment to the waitlisted candidate is bad.
No, I would rather I could take a different way. The authority knew that supernumerary posts can be created only for absorption, not for fresh recruitment.
Or the simplest way, the whatever the bureaucrats who have framed it, they saved their skin.
I say they have saved their skin. But they also probably had the matters of going on, the entire people in the world knew that these proceedings are going on. They also knew ultimately you may have to be. Now, Lordship has said me that the then Honorable Minister in court says that I am not responsible, the officers are responsible. In the criminal court, that was a unique defense by the Honorable Minister that I, as a minister, do not do it. It is done by my subordinates.
Commission.
The other officers, they are responsible, including the commission.
Commission is responsible.
Therefore, absorption, Milord, I wanted to only show this, that when the cabinet memo is prepared and they categorically mention absorb, which would mean that the people were in employment. The next one is, Milord, in the same.
Lord Judge, I'll be asking you to address on this point also. The commission was well aware of the rule
Yes.
position. This is the rule. This is my power. I have to conduct a selection test in terms of these rules. This rule prescribes that this is the procedure to ascertain the vacancy, beyond which I cannot do anything. Now, if this cabinet decision is taken on the suggestion of the commission, whether commission is at fault or who has suggested the somebody has suggested the
I placed the cabinet memo, it will be clear.
whether commission is answerable to explain the situation.
All. But the commission says that I am bound because direction under section 19 of the act is there. That is the plea also. Kindly takes up the School Service Commission Act. Lordship had discussed this cut now. Section 19 will not empowers the state.
Commission 97 Act of the
Lordship দাও বই দাও
আরে ওই বইটা স্কুল কোড আর এই যে এই বইটা I want the act.
The act also, my lord, on the previous occasion.
number 49.
একজন বলো না in the discharge of his functions, the Commission shall be guided by such directions as may be given to it by the state government. Now, then, this is important. From time to time, in conformity with the provisions of this Act.
So if a direction comes from the state, which is not in conformity with the act, then
What it
commission
requires-
can defy it or can
Yes,
say-
legally they can, but it depends on Millard that straightforwardness and Millard uprightness. You are empowered, but the question is whether can you use it as a shield or sword.
This is an independent statutory body. It is expected that
Expectation, Millard, unfortunately, has thrown to Ganges. In one of the affidavits, in another matter, I found that the present incumbent says that I am not going to take responsibility of the earlier activities. I have joined X date, and from X1, this is done, I am responsible. The institutional responsibility, institutional morality has been thrown to wind. Well, I'm very shocked to Millard say these things. I ordinarily do not make any comment of this nature. This is a situation where the entire education's infrastructure is thrown to Ganges. And these are these effects.
so section 19 is the
Section 19, Millard, the government says I issue this direction, section 19, create supernumerary post and give them appointment.
this was the cabinet decision. Direction is part of this cabinet decision.
Yes. Now, will I kindly come to the cabinet decision once again? এটা তো এখানে দরকারটা আছে ও যেখানে স্ট্যাটুট থেকে এক্সপ্লেইন করতে পারছো সেখানে ও করবো
Would you like to take a 5 minutes break?
মাই লর্ড Another judgment on the same volume of the Supreme Court.
1991 supplementary 2 SCC 733.
737.
737.
This is 3 judges bench judgment. 733 দেখালাম।
না
আদালত নেই তো, আমাদের এটাকে বার করতে হবে কোথাও।
আগেরটা 553
Online,
এটা 733, হ্যাঁ।
এটাকে বলে দিন অনলাইনে দুটো
এটাই প্যারা,
বার
sorry।
করে দিন।
এটাও প্যারাগ্রাফ এইটা নেই।
Mr. Dasgupta, do one thing, prepare an index.
I have already prepared, my lord, since all the judgments are.
Yes, prepare index with reference and the proposition on which
No, and the
paragraph.
But this judgment also deals with what is scope of absorption and absorbed employee.
Paragraph 8.
Paragraph 8, 733, 3 judges bench. I would rather place from paragraph 7. The second contention is that definition of expressions absorbed post and absorbed employee in section 2 of the Act are wide enough to take in the sweep not only a person holding an absorbed post before December 20, 1961, but also one who has been merely serving in a higher post, and that accordingly such higher post is also rendered in relation to that person an absorbed post. We are afraid this construction is clearly unsupportable. The definition of this expression in section 2A and 2B of the Act read, absorbed employee means a person who immediately before the 20th day of December was holding an absorbed post, who on and after the date either served or has been serving in that day or any other post in connection with the administration of the Union Territory of Goa. Absorbed post means a civil service or post which existed under the former administration and immediately before 20th day of December 61. These provisions in the interpretation clause merely indicate that an absorbed employee should have held the absorbed post immediately before so and so, and that it did not detract from that position if subsequently he was serving in any other post in connection with the administration of the Union Territory of Goa. It is erroneous to construe that in such circumstances the other post would also become an absorbed post. In relation to such person, he would continue to be an absorbed employee. Therefore, absorbed means someone who is working is taken into job, nothing else. Now, another important judgment on supernumerary, which was cited by Mr. Bandyopadhyay at the preliminary stage, will have immense application and impact on the whole issue. This is 1978 Supreme Court cases online, Delhi, page 82, Division Bench Judgment of Delhi High Court. আমার মার্কিংটা কোথায় গেল? Yes. Now I shall take your lordship to the paragraph 6 and onwards. The background for the administrative action is provided by two central acts, which work in harmony with each other, namely the University Grants Commission Act and the Delhi University Act. Under section 12D of the UGC Act, the UGC, for the purpose of performing its function under the Act, may recommend to any university the measures necessary for the improvement of the university education and advise the university upon action to be taken for the purpose of implementing such recommendation. The above mentioned scheme was proposed by the UGC to the universities in India, a recommendation to improve the university education because the provision of supernumerary post, kindly underline this, because the provisions of supernumerary post to academics returning from outside posts of national importance to their respective universities was a part of the overall improvement of the university education. Similarly, the UGC advised the universities upon action to be taken by them, namely, to make detailed proposals to the UGC regarding what supernumerary posts they would like to create and for the benefit of which the deputationists. Further, the UGC also advised the universities upon action to be taken for the purpose of implementing the recommendation, namely so and so. Therefore, the scheme for supernumerary post is for the purpose of the absorption of the persons who are working. And then next paragraph. The UGC scheme could not be implemented by the UGC itself without the cooperation of the universities. For while the UGC could finance the supernumerary post and attach conditions as to who were to be appointed to this post, etc., the post had to be distributed among the different universities. They would be supernumerary posts of the universities provided by the UGC. The action to implement the scheme, creation of supernumerary post with the aid given by the subject to the conditions attached to the post by the UGC had to be taken by the academic council and the executive council in their respective spheres. Under the Act, the academic council is the academic body. The executive council in the executive body university under section so and so, but I am not troubling a lot with that. Then kindly come to me, Lord, the relevant portion. Paragraph 11. A normal appointment of a university teacher has to be made on the recommendation of a selection committee. This is reinforced by Statute 18A. If, however, the condition of the UGC scheme is that its benefit is available only to persons who had previously held posts in the university, then the implication was that these persons had been recommended by the selection committee before they were originally appointed university teachers, and the requirement of section 6.2 and 18A was satisfied in respect of them at the time of their initial appointments. Thereafter, they went on deputation. After their return from deputation, the question of selection committee did not arise. They were not being appointed as university teachers for the first time. Their comeback was not a fresh appointment, and no recommendation of selection committee was necessary for their comeback. This is respect of respondents 4 who had already been professor at the Delhi University before they went on deputation and who were entitled to return to their post as of right at the end of their deputation. This did not, however, mind, occupying the post of supernumerary professors so that the incumbents of their old post need not be destroyed by their turn. Universities made arrangement that you want better people. He was working in Delhi University, Calcutta University wants to bring him. Then for him a supernumerary post is created. Therefore, supernumerary post, the grammatical meaning also, leads that supernumerary means a number, you are doing something exceeding the number. This concept was developed in a cadre studies. Lordship is well aware, for the IAS, there is a cadre strength. For the IPS, there is a cadre strength. Equally, my lord, in all services, there is a cadre strength. While we are discharging functions, some situations may arise where somebody was found to be working, but may not have any place in the cadre strength. So what do? You throw the man out who was appointed otherwise. Then you create a post which is called supernumerary post so that this man can be absorbed.
Beyond the number.
Beyond the number. Therefore, supernumerary itself is something that you are going beyond the number.
And possibly that is why with the retirement or with this, that post abolition.
This is personal. The man goes, post goes. The cadre strength remains unaltered.
Remains same.
Now, these are all relating to the absorption and creation of supernumerary post.
2007. 2007 8 SCC 160.
So what is your job? The other thing, the vacancies were calculated according to the post sanction, how it works out. Rule 8. Sanction stands for the schools are there. Beyond sanction stand, no teacher can be appointed. So there may be vacancy occurred while advertisement was there. Supposing 1,000 vacancies are there in all government aided, whatever the schools, then advertisement was made. This 1,000 is within the or the sanction strength. Now, before the selection, the final list is according to the why this leverage was given. That maybe during the process, a new vacancy due to retirement or other situations occurred, that will also be included. But it is within the sanction strength. Now, this plus post supernumerary will it offend the sanction strength of the school, where it could be accommodated?
But first of all, this is not a cadre service.
Now, where they will be accommodated? Supposing
That-
this
that-
7,000 or 5,000 teachers are given, then the corresponding.
They will completely without loiter around. Because the rule says you have to first identify the vacancies existing or anticipating. And that's why they say that when you publish,
much match with the sanction strength.
not.
Sanction strength vacancy is
Declared vacancy, rather.
yes, must match with the sanction strength.
That's true.
So if today 5,000 new supernumerary post is created, how this sanction strength will be matched?
It will never match.
Where they will go then?
Loiter around. Loiter around.
X school has requirement of one work education teacher, one physical
Doesn't
education.
matter because this is out of political expediency. The resolution is this. This is not out of that academic expediency. Whenever, first of all, again, if your lordship go to the rules, that the vacancies, the categorizations are there. Before you declare, all these categorizations are taken into a bucket. Then it declare it. Even the rule says that it may so happen that before the final selection, 15 days before the publication, also vacancies, which should also be declared that these vacancies come. So that final vacancy position is terminated on that date. Thereafter, any vacancy that would go for the next year's selection.
No, these 5,000 odd vacancies were, when it was declared to be filled up, but treating it as a supernumerary, was the sanction strength of the corresponding schools
Yes.
were taken into account?
Kindly come to the rules once again.
No, it was taken into account.
Yes.
Cabinet decision that there was a.
Cabinet decision did not at all consider that.
That is what the cabinet decision. Cabinet
Cabinet decision doesn't say that. What is troubling my lord's query? The cabinet decision doesn't say that. Cabinet decision says the selection is over, the waiting list people are there, they are demanding employment. Therefore, to tackle the situation, we create this.
Supposing supernumerary post can be created, supposing, but you have to fit in these persons against some post which are sanctioned post.
Now this is new creation of post.
Where they will go?
That is, but I could only say, my lord, they will simply loiter around. Where is the assessment?
How the salary would be paid? Because the
Special sanction? Cabinet had to specially sanction fund for this. Can't read the cabinet decision. Shocking in every respect. They say for this purpose, finance department says, I had referred it to your lordship. This is a proposal of school education department, a part of the cabinet decision with a paragraph 5, views of finance department. The Finance Audit Department, Government of West Bengal, has agreed to the proposal of the School Education Department, VD so and so, with the following observations. This is a proposal of School Education Department for creation and filling up of 5,261 supernumerary posts of teaching and non-teaching staff, and creation and filling of another 1,600 supernumerary posts for work education, physical education, involving a sum of
Not
rupees.
for creation. A school education department proposal was absorption.
No, that cabinet says absorption. My lord is rightly striking. They say creation, cabinet says creating for absorption, not for fresh recruitment.
Is there any difficulty for finance to sanction the financial or the accord the financial sanction if it is absorption or there?
No, only say if these posts are created, which are beyond the budgetary understanding,
Mhm.
then we have to bear the additional cost of 262 crores. Now,
Lack of harmony.
that if your lordship go detail into it, my lord, more shocking things would reveal. Now, my lord, my learned judge insists me to cite another judgment. I just place it. Though to me, my lord, these points have been already cited. This is 2007, Volume 8, Supreme Court Cases, page 161.
Paragraph 911.
What about the paragraph 9? Judgment of Justice SBC, I believe. Yes. Recruitment for teachers in the state of Rajasthan is admittedly governed by the statutory rules. All recruitments, therefore, are required to be made in terms thereof. Although Rule 9.3 of the rules does not specifically provide for the period for which the merit list shall remain valid, but the intent of the legislature is absolutely clear, as vacancies have to be determined only once in a year. Here, the rules prescribe that. Vacancies which arose in the subsequent years could be filled up from the select list prepared in the previous year and not in another manner. Even otherwise, in absence of any rule, ordinary period of validity of select list should be 1 year in state of Bihar, so and so. And then paragraph 11, it is well settled principle of law that even selected candidates do not have legal right. Paragraph 12 is quotation from another judgment. I just will not read it. It is settled legal position that merely because a candidate is selected and kept in the waiting list, he does not acquire any absolute right to appointment. It is open to the government to make the appointment or not. Even if there is any vacancy, it is not incumbent upon the government to fill up the same, but the appointing authority must give reasonable explanation as with regard to if they do not want to fill it up, why is they given it? Nothing else. Therefore, the principle is that
Here in the case, it is an admitted position, panel has expired. That has been appointment beyond the time has sought to be justified, that since there was a delay in completing the selection, it has automatically extended.
automatically. No, since the matter was pending before the court. It's a fantastic logic. Anyway, now another point, Lord, which I am just concluding. Lordship has seen below the section 19. এটা হচ্ছে আমাদের ডিভিশন বেঞ্চ জাজমেন্ট।
This is division bench.
Lord, no, not this division bench.
No.
Lord, this bench was presided by Justice Talukdar.
Oh.
Lord, when
What
Lord,
was
the
the issue before the
Park Commission's report and other things were considered, here question counselor about the authority of the state to issue directions under section 19 beyond the provisions of the Act. But kindly come to 4.6.4. That কিচ্ছু দরকার নেই। আরে আমি ডাক দিলাম, এটা বলি অন্য কোনো দরকার নেই। We have already observed that 4.6.4 that Mr. Taposh Paja, Senior Law Officer of the School Education Department, has stated before the inquiry committee that his opinion was not obtained at the time of constitution of the Supervisory Committee of November 1, 2019, though Mr. Manish Jain has tried to justify the constitution of a supervisory committee under section 19 of the School Service Commission. Mr. Manish Jain was the secretary. Under section 19 of the School Service Commission Act, as advised by Law Branch of the School Education Department. In view of the contradictory statement between Manish Jain and Taposh Paja, and in absence of availability of any written opinion, Mr. Paja, we are of the view that the opinion of Mr. Paja was not obtained at the time of constitution of the Supervisory Committee. On consideration of the provisions of section 19 of the Act, we find that state government can give direction from time to time to the Central Commission in conformity with the provisions of the Act, by which Commission will be guided in discharge of its function. In our considered view, the constitution of a committee by order dated so-and-so to supervise, monitor, and guide the functions of the Central Commission in connection with the pending recruitment process by the persons who are not part of the Central Commission, and by making Dr. Shanti Prasad Sinha as convener of the said committee, who is neither part of the School Education Department nor holding any sanctioned post of the Central Commission, cannot be construed as direction of the state government in conformity with the provisions of the School Service Commission Act 1997. Therefore, even the constitution of a committee by the minister, all of them are now in custody, was found by this division bench beyond the provisions of section 19 of the Act.
So this question possibly I also asked in some other matter, where it came to the notice of this court while taking in the other determination that at one point of time the commission was directed not to deal with any matter. School Education Department took over all charges. Then whether the question was whether a statutory commission which was been created
Could be defunct.
could be defunct by this. Now here section 19 is subject to this. Now this is an independent statutory body. It may at least point out to the state that here there are places where your direction offends the rules which is operating in the field of appointment. Is it not the obligation of that statutory body to point out?
Was it? That's their main duty. They are created for that. But as I say, because you have been empowered, the question is whether it will use it as a sword or as a shield depends on your own.
As you are right from the beginning, you are highlighting even the executive instruction under Article 162, possibly, whatever, that this is subject to the other provisions of the Constitution. So the mechanism is such that to look into adherence to Article 14, these bodies are there. So
They are created, they are the trustees of the people's right.
exactly. If they fail to discharge that, it is nothing on record to suggest, at least to return to the request of the government that these are the areas where commission cannot do that or is supposed to not to act in that manner because of these restrictions of the rules, but this has not been done.
On the contrary, they have recommended. This memo, cabinet memo says School Service Commission has recommended.
recommendation comes after this decision of the cabinet.
Kindly come to it.
Page 3, 4, internal page 3. Page 3.
You kindly come to the internal page 2. There Lord shall find the chairman of the Central School Service Commission.
মুলতানি না করে এর উপরে লেখো বিকাশ বাবু দিকে।
Page 2 of the internal page 2. Sorry, 3.
3
Supplementary affidavit, page 5.
লিখে দাও, ওটা দাও, এক মিনিট দাঁড়াও ওখানে, আমার কাছে আছে, একটু এদিকে কানটা খাড়া রাখো, গল্প করো না বসে। আচ্ছা ধরুন এই বান্ডেলটা একটু নামান, এরপরে three, internal page 3.
Yes, the proposal of Central School Service Commission and Commissioner of School Education under the heading. Got it? The Central School Service Commission, Chairman West Bengal Central School Service Commission, with a letter dated so and so, placed a report to the state government stating that 5,261 numbers of candidates have been affected by rank jumping in the first SLST and third SLST, and 1932 posts of assistant teachers for class 9-10, 247 for assistant teacher 11-12, 1102 posts for group C, and 1980 posts for group D. And if all these similarly posted candidates like Shoma Das are to be recommended, 5,261 posts are required to be created.
So this is a suggestion of the commission.
Yes. Then the chairman School Service Commission further, days later dated so and so, placed a report to the state government stating that there are 751 numbers of candidates for 11-12 group C, group D who are not in any list, either in panel or in wait list. The West Bengal Secondary Education has also confirmed the fact of such appointments of non-teaching staff beyond the list prepared by the commission. The chairman of the commission further stated that for teaching posts 9, 10, 11, 12, who do not feature in any list, either in panel or wait list, should be cancelled by the commission without waiting for and direction of the Honorable Court. This was honest suggestion. Similarly, for cases relating to non-teaching candidates group C, group D who do not feature in any list, may cancel the appointment letter directly. Proposal of the Commission for School Education is, the Commissioner of School Education with his proposal dated so and so proposed to create such number of posts.
So this is a proposal.
Observe. The School Service Commission says that they should be terminated.
Whatever those names are.
Now, the Commissioner of Education, that is the official secretary of the Education Department, he says that 16 numbers supernumerary post, breakup 750 work education, 550 physical education, to absorb all waitlisted candidates of physical work education subject to validation of panel.
Just the off the track. Now, if the commission has all the records to identify 1932 assistant teachers for 11, 12, 247, 19, 247 for 11, all the numbers, including group C, group D, suggesting the cabinet to cancel their at a go. What is the difficulty in identifying them?
You go on searching difficulties. we cannot have an answer. And that too for a particular category whose names were not in the list. They were appointed. The other things are there.
So to this, can we take a look of the commission's affidavit here?
Yes, kindly see the commission's affidavit. SSC has also made a supplementary affidavit. মেনটা দাও
দুটোই দাও, সব দাও আমাকে, ওটা খুলে ধরে দাও, ফাইলটা ধরে
সিদ্ধার্থ
দাও,
মজুমদার এটা তো।
ভাঁজ করে ধরে দাও। One is of supplementary.
সিদ্ধার্থ মজুমদার has affirmed this affidavit. তেইশে নভেম্বর দেখছি তো।
One was given affidavit in opposition on 28th November 2022.
28
Affirmed.
November. Yes.
Other supplementary was affirmed on
Supplement on 19 February 2024.
24.
Number, they have wasted 3 pages on the ground of maintainability. Let's start from paragraph 7. Paragraph 6, all maintainability by statutory body. Now paragraph 7, their statement comes.
Opposition or supplementary?
Opposition.
Paragraph 7.
28 November.
Paragraph 4. 7, yes.
It's important to read. I'm reading there. I deny that the petitioners are entitled to be called for verification or that there are several discrepancies or illegalities in the merit list. My lord is not dealing with that. I'm not troubling my lord.
No.
Then kindly come to me, Lord, paragraph 9. With regard to government order dated 19th September 2022, got it? Whereby the government proposed to create supernumerary posts for assistant teachers. I say that the government order came as a policy of the government for accommodating waitlisted candidates. The commission, merely being the recommending authority, has no role to play other than implementing the directions of the school education department.
Correct. It is not correct.
Absolutely betraying the trust.
This commandant decision suggests that this was actually initiated from the end of the
School Service Commission suggested. Government investment for which it issued notice it as which is merely a schedule for conducting the counseling of assistant teachers for work education. I deny that notification referred to a complete violation of Rule 12.4 of the rules. I say that the Rule 12.4 deals with upper primary teachers except physical work education. The petitioners belonging to are not governed by 12.4 but governed by 13.9, all the same. Then with regard to the petitioners being called for verification after the creation of supernumerary post, I say that the question did not arise as the supernumerary posts were created for the leftover waitlisted candidates who are actually successful candidates, who could not be recommended for want of vacancies. But if they could not be recommended for want of vacancies, how could they be successful? Then everybody is successful. If the vacancies are marked, if anyone who doesn't come within the purview of the vacancy is unsuccessful.
What is about the expiry of panel? Is any suggestion and any statement regarding expiry of panel here?
Well, I do not find, my lord, about their statement that, yes, kindly come to me, lord. No, nothing is there. State policy is my automatic extension, but the SSC in the first affidavit doesn't say anything on that, but in the C, the supplementary affidavit. Oh, I mean, the supplementary affidavit, they have annexed the application by which they wanted to say that these posts are created to accommodate illegal appointees. Therefore, the SSC, in fact, which your lordship, I think, is trying to search out, has betrayed the confidence vested on them by the statute.
If a statutory body does not work for which it has been created, removal of the
Yes, but the state is empowered to dissolve it. State didn't want to dissolve them. State didn't want to will not use them for these illegal purposes.
the of the post holders, rather the office bearers should be removed, or the entire commission?
Entire board will be dissolved.
of the-
The law say permits them. The Barker provision था. আমি যা বলছি সেটা দাও। ও ফার্স্ট প্যারাগ্রাফে ফার্স্ট অ্যাফিডেভিটে ও বলে জাস্ট এ মিনিট দেখি। Oh yes, no, on the expiry they admit it. I am thankful to my junior. Page 3 of the first affidavit, subparagraph D.
Yes, I have also marked it.
ওইটা একটা প্রভিশনটা রিজলভ করতে পারে। That they can dissolve the body.
Yes, school
Section 20 of the Act. কি বুঝবে বলো তো? এই যে তো মাথায় ঢুকলোই না।
Page number to
পরে বলবো। পরে পিছনে। Section 20, dissolution of the commission if the state government is of the opinion that the commission has failed to discharge its functions under this act. In accordance with the provisions of this act, the state government may, by an order published in the official gazette and stating the reasons thereof, dissolve the commission with effect from such date as may be specified in the order. Upon the dissolution of the commission under so and so, all the members of the commission shall be deemed to have vacated their office.
see, selection test is over.
It was over yesterday.
Yesterday, it
The
is over.
examination.
This 14th one examination was there.
Right, right.
The written exam for 9, 10, 11, 12, that is complete.
Exhibition में जाना था.
What else then?
The selection process is like that, so many things.
Manipulation, everything debates.
No, at this stage that cannot be switched over to any other body.
No, that you do not do it.
That will create another chaos. No?
The judges of these courts are maligned every day. And I don't want to see that the other, you have already sufficiently maligned. No. No.
No, only I was inquiring, there is a power for the state government to dissolve.
Yes. Okay. Para 352.
Therefore, the whole scheme of the act is a complete one.
It's a complete, watertight code, if I may use that expression. If you follow the statute, then there is a scope for any seeping of corruption. No. And you have to be transparent. Everything has to be transparent.
Should we continue in the second half or tomorrow?
No, I'm taking a দ্বিতীয় মামলা আছে।
হ্যাঁ, চারে। আর এখানে জিটিএ
Oh, I'm second half is GTA matter.
Second half is in the GT.
But tomorrow I will take another 15-20 minutes.
And ask Mr. Advocate General to start tomorrow.
আজকে রাখছি না।
আজকে
First
না।
half.
কালকে সে সকালে
28 মিনিট জোর।
এই GTA টা আমাকে নর্থ বেঙ্গলে দিয়েছিল।
But tomorrow at 2?
2 or 10:30. Because if you complete, then I ask with the Advocate General to start.
Then not lordship, if your lordship give me this indulgence, may it start at
2 p.m.
no 2 p.m. or 11:30?
Very well, some motions are there after.
Right.
After some motions.
So that
Convey it to Mr. Advocate General.
I can earn something here and there.
it. Item number 2 and 3, millet. I say sorry, millet. Kindly pardon me, millet.
The CAB matter.
I'm sorry, millet. I'm extremely sorry, millet.
No one was there for the petitioners in other two matters. To wait, let me deliver. It solve. The GT
Or in any event that will bind us, millet. When dealership may pass a common judgment over all.
No, not common judgment. You have
As
to
dealership
wait for
cases.
that. Wait. Let this point be decided first, then I will take up. Now, call this. Concluded his submission.
Yes, so far, 3 and 13 is concerned, he has concluded.
And have you submitted, after hearing
He has
Mr.
started.
Kaur, you will be filing your written
Reply.
notes.
Yes. No, written notes primarily you have submitted.
Primary submitted. ওটা দেখো তো কোথায় আছে written notes টা. Now that pen drive you handed over to me with a hard copy also. Across the sea. That actually that is regarding his submission. So far he has made. Now in the pen drive there is a list of dates and the other document. Is it necessary for today, the list of dates?
I have an extra copy. I'll give it to you in case.
No, that soft copy he has given me there across the sea.
He must have
So-
gone there to earn some money. My lord was there.
mentioning allow হয়নি তো mentioning allow হলো
No, these are the কোনটা আচ্ছা আছে তো এটা রাখুন, ওটা কিন্তু আলাদা আলাদা করে রাখুন. Now he has given me the hard copy also of your argument.
Yes, ma'am.
List of dates would be relevant today.
Lord,
Now what you have, now I have gone through it. What you have, so
Lord,
far
I
you
have only spoken about the interplay between the three acts. I have shown your lordships the provisions of the three acts.
No, let me understand.
I'm
You understand what
I'm
I have got.
I'm sorry.
Now, first of all, the Gorkha land movement is complete breakdown of administration.
Yes.
This is the situation which actually prompted the administration to take this step
Yes.
for these absorption or regularization of guest teachers. This is one part of your limb of your submission
Yes.
you have made. Now,
Lord, I-
so far the stipulated requisite qualification of the B.Ed is concerned. Your ultimate submission which has been given,
since there is however no penal provision prescribes that non-acquiring of such qualification which is within such stipulated time frame, a teacher may lose his job. So you take note of this.
Lord, I will come to that point. Lord, there are little gaps, Lord, in the note that has been given. This conclusion is given to your lordships too early, Lord, because I will have to develop to that point, Lord, for provision, penal provision in the statute, because Lord, as I said, Lord, I have only shown your lordships the interplay.
Let us understand one thing.
Yes.
This 313 appointment, which I am now considering, that was not followed in the regular employment
Yes.
Procedure has not been followed. There is no dispute with regard to that.
Correct.
You are now trying to justify such employment. First is the situation prevailing in the hill region at the time when the appointments were made. This is the
But
factual
since
state.
99, my submission would be, since 99, there has been no recruitment in the hill region. Even when the under the School Service Commission, the regional commission was there was no recruitment because of the disturbance which was going on